Okay, let's unpack this. Today, we're diving deep into the foundations of a nation, the Turkish Constitutional System. Now, that might sound a bit dry, like a textbook topic,
Yeah, it can seem that way sometimes.
but really, it's about the core rules. How state power works, how individual rights are protected, what shapes the country's identity. It's absolutely essential stuff for understanding Turkey.
It truly is. Think of it as the blueprint, really, for how a society organizes itself legally and politically.
And for this deep dive, we've got quite a stack of material here. Articles, research, some pretty detailed notes all laying out this blueprint. They cover, well, everything. From the fundamental concepts like what is a state, what's a constitution, right through to the history of Turkey's governing documents.
And then the specifics, the nitty-gritty of how its parliament, presidency, and judiciary actually work today, including, of course, rights and freedoms.
So our mission, I guess, is pretty clear, that take all this, dense material and just distill it.
Exactly. We want to pull out the most important bits of knowledge, the key insights, maybe some surprising details too, give you a clear understanding of how it all fits together.
Kind of a shortcut to getting well-informed without drowning in detail.
That's the idea. A guided tour, if you like.
Okay, so here's where it gets really interesting. We'll explore the different forms constitutions can take and see how Turkey's own history has shaped its current system.
We'll definitely zero in on those core principles defining the Turkish state today. Things like, what it actually means to be a unitary state or secular or a rule of law state.
And naturally, we'll spend a good chunk of time on the main pillars of government: the parliament, the Turkish Grand National Assembly, the TBMM.
The presidency, which has seen some major changes.
Right, and the judiciary, including the really vital role of the Constitutional Court. Plus, we'll look closely at the framework for your fundamental rights and freedoms, how they're protected, and importantly, how they can be limited.
Which is always a key point in any constitution.
So what does this all mean for you listening? It's about getting a clear picture of the fundamental rules governing life and national affairs in Turkey, understanding how power is structured, and crucially, how it's meant to be constrained by law. This deep dive is, well, it's tailored for you, designed to be an engaging journey through this stuff. So let's jump in.
All right, let's build from the ground up. The material we have kicks off with the very definition of a state. It's described as basically a public power entity formed by people in a specific territory under a political authority.
Okay, so people, territory, and sovereignty. That's the power to govern that territory and people.
Exactly. Those are the three essential elements the sources identify. Simple enough to start. Now, states can take different forms. Our sources focus quite a bit on the unitary state model.
Unitary meaning?
Meaning political authority is concentrated in, one single center. There's one constitution, and the laws made by that central authority apply everywhere, nationwide.
And Turkey is presented as a classic example of this, along with France, maybe.
Precisely. That's what the sources say. And they contrast it with, say, federal states where power is shared between central and regional governments, think the USA or Germany.
Or even regional states like Spain or Italy, which have some power devolved but aren't fully federal.
Right. But Turkey, based on these sources, is clearly defined as unitary. Power flows from the center.
That clarity helps. Now, the Constitution itself, the sources discuss its meaning in two key ways.
Yeah, there's the material meaning, which is about the substance, what's actually in it. So the rules defining state power, guaranteeing fundamental rights against that power, and organizing the government, legislative, executive, judicial branches.
Okay, the content and the formal meaning.
That's more about its status, its supremacy in the whole legal hierarchy. The Constitution is the highest norm. No other legal rule, no law, no decree can contradict it.
And changing it is harder.
Exactly. It's created and amended through a special, more difficult process than ordinary laws. And crucially, there's a body, the Constitutional Court, whose job it is to check if other laws actually measure up.
So it's the ultimate rule book, and everything else has to comply.
Precisely. The top of the pyramid. The sources also classify constitutions in ways that tell us something about Turkey's, for instance, written versus unwritten.
Turkey's is definitely written, right? One main document.
Yes, contained in a single document. Unlike, say, the UK's constitution, which is more based on tradition, laws passed over time, conventions, it's not all in one place.
Got it. Codified.
Then there's the level of detail. Is it casuistic or detailed versus a frame constitution?
And Turkey's 1982 constitution falls into which category?
Casuistic, according to the sources, it's quite long, goes into a lot of specific detail on many points. A frame constitution, like the U.S. one, is much shorter, sets out the basic structure and rights, and leaves more specifics to ordinary legislation.
So Turkey's current constitution tries to cover a lot of ground within the document itself. More prescriptive.
It's how it's characterized, yeah. More exhaustive. And finally, rigid or strict versus flexible.
This is about how easy it is to change.
Exactly. The 1982 Constitution is rigid. It's designed to be harder to change than ordinary laws, needing special procedures, often higher voting majorities, and critically, as we'll see, it contains articles designated as unchangeable, period.
Unchangeable, wow.
But what's fascinating is the contrast. The sources highlight that Turkey's very first constitution, the 1921 document, was actually the only flexible constitution the country has had. It could be changed just like any ordinary law.
That's a huge difference right there in the history. So how are constitutions made and changed in Turkey today under the rigid 1982 one?
Well, the primary power for amendments lies with the parliament, the Turkish Grand National Assembly, the TBMM.
But not just them.
No. The president plays a role, can send things back, and crucially, the voters often get the final say through referendums, especially for major changes.
Okay.
The sources also make a distinction. They talk about original constituent power. That's the power that creates a brand new constitution, maybe after a revolution or major upheaval, unbound by any existing rules. Versus derivative constituent power, which is the power to amend an existing constitution, working within the rules set out by that constitution.
Got it. Creating versus modifying. Okay, that lays the groundwork. Now, let's step back and trace the journey a bit. Because Turkey's constitutional history isn't exactly a smooth, straight line, is it?
Not at all. It's marked by really significant shifts, often following major political events or, well, interventions.
The sources point to the 1876 Kanuni Asasi, the Ottoman one, as the starting point for this modern history.
Right, the beginning. But the story really gets going with the constitutions of the Republic era leading up to the current 1982 document.
Starting with the 1921 Teşkilat-i Esası. What's the headline there? What's its big contribution?
Its major contribution, really, is introducing the principle of national sovereignty. Power flows from the nation. That's huge.
Foundational.
Yeah. The sources note it was exceptionally brief, just 24 articles. And as we just mentioned, uniquely flexible. Changeable like any law. It set up an assembly government system, power concentrated in the assembly. But, significantly, it didn't explicitly establish judicial independence. That's a key omission.
Interesting. So, foundational, but maybe incomplete by later standards. What about the next one, 1924?
This one drew inspiration from the French Declaration of Human Rights, so rights were more prominent. But, the sources tell us, the scope was still limited, mostly civil and political rights. Notably, no social rights were included initially.
So things like right to work, Social Security, not in there at first.
Not constitutionally guaranteed, no. Secularism also evolved under this constitution. Initially, it actually stated Islam was the state religion.
Really?
Yeah, then that was removed in 1928. And finally, the principle of secularism itself was formally added in 1937, so a gradual process. It also kept a single-chamber assembly.
You can really see the concept of secularism developing within these documents over time.
Absolutely. It wasn't just switched on. Then comes the 1961 Constitution, and the sources identify this as a major turning point.
Why is that? It followed a military intervention, right?
Yes, it did. And it was drafted by a constituent assembly. This one included civilian representatives, and the sources suggest it was seen as more broadly representative, more participatory than the body that drafted the 1982 Constitution later.
Okay, and this is where some really key principles defining the modern republic were first formally introduced.
Exactly. The sources list these explicitly as characteristics of the republic. It should be a human rights-based state, a rule of law state, a democratic state, a social state, and a national state. That was a really significant declaration of the state's identity and goals.
A much clearer shift in the state's self-definition compared to before.
Definitely. It also introduced the full separation of powers doctrine and a proper parliamentary system.
Yeah.
It moved to a bicameral assembly, 2 houses with the Senate alongside the National Assembly.
And the president's role
Became more limited, more symbolic, politically neutral, or irresponsible in the technical sense in this era. Judicial independence was explicitly established. And crucially, 2 major judicial bodies were created. The HSK, the Council for Judges and Prosecutors, and the Constitutional Court.
So 1961 is really where modern judicial review and those social rights we mentioned get their constitutional footing for the first time.
Absolutely. Social and economic rights were included, and the sources characterize it overall as more individual-centered than the later 1982 document, more focused on rights and freedoms.
That's a key distinction. Did it last unchanged?
No, the sources mention amendments between 1971 and 73 that actually restricted some rights and strengthened the executive, kind of anticipating some themes that would appear more strongly in the next constitution.
Which brings us to the 1982 Constitution, the current framework, also born out of a military intervention.
Yes, another intervention. Created by a constituent assembly considered less representative than the 1961 one, it had a military wing and an appointed civilian wing, no political parties involved in the latter. And it was adopted via a referendum that was uniquely combined with the presidential election for the leader of the intervention.
An unusual way to adopt a constitution. How did it compare to the 61 version, according to the sources?
When comparing it to 1961, the sources consistently note it was designed to be more detailed, more casuistic, and more rigid, harder to change. It significantly strengthened the executive branch. It returned to a single-chamber assembly, ditching the Senate. And overall, it represented a move towards a less participatory model of democracy compared to its predecessor, at least in its initial form.
So if 1961 expanded rights and checks on power, 1982, at least initially, seemed more focused on consolidating power, particularly in the executive,
Yeah.
strengthening the state.
That's the general picture the sources paint of its origins and initial design. They also lay out the core identity elements enshrined right at the start of the 1982 Constitution. The state's indivisible integrity, its territory, and nation forming a whole.
Okay.
The official language, Turkish. The flag, the national anthem, İstiklal Marşı, and the capital, Ankara. These are defined up front.
And here's a really fundamental point you mentioned earlier, coming from the sources.
Mm.
The first three articles of the 1982 Constitution,
Right.
they're untouchable.
Absolutely untouchable. They cannot be changed, and it's even forbidden to propose changing them.
Wow. What do they cover?
Article 1 defines the form of the state as a republic. Article 2 lists the characteristics of the republic: democratic, secular, social, rule of law state, respecting human rights, loyal to Ataturk nationalism. Article 3 reaffirms the indivisible integrity, the language, flag, anthem, and capital.
So these are the absolute non-negotiable pillars as defined by this Constitution. Bedrock principles.
Exactly. And the preamble reinforces this, emphasizing the nation's absolute sovereignty and stressing that no state authority can be exercised unless it derives its source from the Constitution itself.
Let's pick up on that idea of sovereignty belonging to the nation. How does that translate into the core principles defining the state under the 1982 Constitution?
Well, the sources underline that this national sovereignty isn't just an abstract idea. It's exercised concretely by the state's authorized organs, the legislative, TBMM, the executive, president, and the judiciary, independent and impartial courts, but only according to the principles laid out in the Constitution.
So power comes from the nation, but must flow through these constitutional channels.
Precisely. No individual, no group, no social class can just claim sovereignty for themselves. And no state authority is legitimate unless it has a clear basis in the Constitution.
And this leads directly to the concept of separation of powers, doesn't it?
It does. The sources describe this not as a super strict, walled-off separation, but more as a civilized division of labor and cooperation between the branches.
The TBMM making laws, the president executing them, the courts interpreting and applying them.
Right. And the sources note impartiality was explicitly added alongside independence for the courts in 2017. Crucially, the Constitution views this division as cooperation, not a hierarchy where one branch is inherently superior. The Constitution and the laws themselves are supreme, guiding this interaction.
Okay, so they work together, but within their distinct constitutionally defined roles. Let's dive into some of those key principles, the characteristics mentioned in those unchangeable articles. Secularism, Lake.
A central one, definitely. The sources define this through several elements. First, a clear separation of state and religious institutions. Second, no official state religion. Third, the state must be neutral towards all religions and beliefs.
Neutrality.
Yes. And fourth, legal rules don't have to conform to religious rules or dogma. Law stands independently.
How does that play out for individual religious freedom?
The sources describe freedom of conscience and religious belief as absolute, untouchable. Freedom of worship, performing religious ceremonies and rites is permitted, but it can be limited by law for specific reasons, like protecting public order, safety, or the rights and freedoms of others.
So belief is absolute. Practice can be regulated under strict conditions.
Exactly. The sources also point to the preamble statement that sacred religious feelings shouldn't be mixed into state affairs or politics. They mention the Dianet, the Directorate of Religious Affairs, exists as part of the administration, but is meant to operate in line with secular principles, and religious culture and ethics is noted as a compulsory school subject.
So it's a complex picture, a framework aiming for state neutrality and freedom of belief, while the state also maintains a specific institution for religious affairs and mandates some religious education.
It is complex. Another crucial principle is the rule of law state, who cooked the lady. The sources frame this very clearly as the opposite of a police state, meaning a state where all actions and decisions, especially those by the government and administration, are bound by legal rules. Citizens have legal certainty, they know the rules, and can rely on them.
And this principle first became explicit in the 1961 Constitution, you said.
Correct. That's when it was formally named as a characteristic. The sources list its key components. The Constitution and laws are supreme and binding on everyone, including the state itself. All state actions and decisions are subject to judicial review. You can challenge them in court.
That's fundamental.
Absolutely. Plus, separation of powers, judicial independence, the right to a fair trial, guaranteed fundamental rights and freedoms, legal certainty, equality before the law, the guarantee of a legal judge, meaning you can't just set up special courts, a legal administration, acting based on law, state financial liability for damages it causes, and adherence to general principles of law.
That comprehensive legal accountability of the state, that feels like the core promise here.
It really is. The fact that you can take administrative actions to court for review is presented as a direct result of this rule of law principle.
Okay. What about the social state, social devlet?
Also introduced formally in 1961, the sources define it as a state that actively aims to achieve social justice and ensure social equality. They distinguish it clearly from a socialist state, which would focus on state ownership of production.
So it's more about welfare and opportunity.
Yes. Its goal is to guarantee social and economic rights for citizens, things like healthcare, education, social security, taking positive steps to ensure a certain standard of living and well-being.
Got it. And the principle of Ataturk nationalism, how do the sources describe that?
This is characterized in the sources as a subjective understanding of nationhood. It's not based on objective criteria like race or language or religion.
So not an ethnic definition.
No, explicitly not, according to the sources. It's based on things like a shared history, a shared memory, a desire to live together, and a collective will to protect that shared heritage. It's presented as a unifying, integrating principle.
A civic nationalism based on shared values and citizenship.
That seems to be the interpretation, yeah. Its legal consequences, mentioned in the sources, include the idea that everyone bound by citizenship to the Turkish state is considered Turkish, regardless of their background, Turkish being the official language, the principle of the state's indivisible integrity reinforcing that unitary state idea, and the prohibition of activities that could endanger the unitary state or lead to division.
Okay. And again, those unchangeable articles lock in the Republican form. These characteristics, democratic, secular, social, rule of law, national, and the state's fundamental integrity, language, flag, anthem, capital.
Those are the constants.
Let's shift focus now, maybe more directly to you, the listener, and the rights and freedoms the Constitution outlines for people living in Turkey.
Right. This is obviously crucial. The sources track the evolution we touched on. Very limited rights mentioned in 1924, then social rights added in 1961, and increasing influence from international human rights documents like the Universal Declaration of Human Rights, UDHR, and the European Convention on Human Rights, ECHR, shaping both the 1961 and 1982 constitutions.
And you mentioned 1982 was initially seen as maybe more focused on state authority than 1961's individual focus.
That's the initial characterization, yes. But the sources strongly emphasize that the 1982 Constitution has undergone significant amendments over the years. Many of these were driven by efforts to align with European Union standards and the judgments of the European Court of Human Rights. These changes have substantially strengthened rights protections compared to its original form.
And there's that specific constitutional provision, Article 90, giving international human rights agreements special weight.
Yes, that's a really important one. A 2004 amendment to Article 90 states that if there's a conflict between domestic laws and international agreements concerning fundamental rights and freedoms agreements, that Turkey has properly adopted the international agreement prevails.
That's a powerful statement, a direct link to international standards.
It is. It means international human rights law has direct effect and priority in certain circumstances.
Okay, now the 1982 Constitution itself categorizes rights into three main groups.
Yes, broadly. Personal rights and duties, social and economic rights and duties, and political rights and duties.
Can we pull out a few examples from each category just to get a feel for what's covered, starting with personal rights?
Sure. This category includes really fundamental things like the right to life, personal inviolability, freedom, and security of the person.
Privacy.
Yes. Privacy of private life, secrecy of the home, secrecy of communication. Generally, searches, seizures, or restricting communication require a judge's decision. There are exceptions for urgent cases authorized by law, but even then, it needs judicial approval very quickly, usually within 24 or 48 hours, depending on the situation.
Okay, procedural safeguards.
Right. Also, property rights are guaranteed, though they can be limited by law for public interest. Freedom of religion and conscience is absolute, as we said. Freedom of thought and expression, nobody can be forced to reveal their thoughts, and you can express them freely through speech, writing, images, etc. Freedom of science and art. Press freedom.
The sources also highlighted some rights that specifically don't require prior permission from the authorities.
Yes, that's an important list. It includes forming associations, forming trade unions, establishing political parties, setting up printing presses, publishing newspapers or magazines, and holding meetings and demonstration marches. For these activities, you don't need to ask for permission beforehand, though there might be notification requirements or regulations about how they are exercised.
That's a clear protection for civic space and public expression. Okay, how about social and economic rights?
This covers areas like the right to education and learning. The sources note primary education is compulsory and free in state schools. But they also specifically point out there's no constitutional right for Turkish citizens to be educated in languages other than Turkish as their mother tongue within the education system.
That's a very specific point from the sources.
It is. Other rights include protection for agriculture and farmers, the right to housing, with the state having a role in planning to meet housing needs, protection of youth, state measures for their development and protection from harmful habits, the right and duty to work, with the state tasked to improve working life, protect workers, support the unemployed, freedom to contract, right to health services, environmental protection, and the right to Social Security.
So a mix of individual rights and state responsibilities aimed at social well-being. And finally, political rights.
This starts with Turkish citizenship, who is considered Turkish. The sources note citizenship can only be stripped based on a court decision, meaning there's judicial review. Then there's the right to petition the authorities, the right to information, and the right to apply to the ombudsman, or public inspector.
Who can use those rights? Just citizens?
No, the sources say the right to petition, get information, and apply to the ombudsman are available to both Turkish citizens and foreigners residing in Turkey on the basis of reciprocity. Access to information can be legally limited for things like state secrets, national security, or ongoing criminal investigations. Ombudsman decisions aren't binding, but can be influential, and the process itself is subject to judicial review.
Okay, other political rights.
The core ones: the right to vote, to be elected, and to engage in political activity, and the right to establish political parties. The sources mention a minimum of 30 citizens is needed to form a party, and it gains legal personality automatically upon submitting the required documents to the Ministry of Interior.
So the Constitution lays out this broad framework of rights. But rights are rarely absolute. How can they be limited, or, in really extreme circumstances, suspended?
This is a critical aspect, especially for a rule of law state. The sources are very clear on the rules for limitation. First, any limitation must be made by law, not by a presidential decree or regulation, only by a law passed by Parliament.
Step 1. Must be in a law.
Step 2. The limitation can only be for the specific reasons mentioned in the relevant constitutional article for that particular right. You can't just limit a right for any reason.
Okay, specific grounds.
Step 3. The limitation must be proportionate to the aim pursued. It shouldn't go further than necessary. Step 4. It cannot violate the fundamental essence or core of the right itself. And step 5, it must conform to the letter and spirit of the Constitution and, importantly, the requirements of a democratic society order and the principle of secularism.
So a whole series of strict conditions that have to be met.
Absolutely. It's designed to be a high bar. And the sources highlight something even stronger: the hardcore rights. These are rights that can never be limited or suspended, not even during states of emergency or wartime.
The non-derogable rights What are they, according to the sources?
The right to life, except for deaths resulting from lawful acts of war. The integrity of one's material and spiritual existence, basically, physical and mental integrity. The absolute prohibition of torture or ill treatment. The principle that you can't be considered guilty until proven so, presumption of innocence. And the principle of no crime or punishment without law, nulla pone sine lege, including the prohibition of making punishments harsher retroactively. Also, no one can be forced to reveal their religion, conscience, thought, or opinion, or be blamed for them.
These are the absolute bottom line, protected under all circumstances.
Exactly. Suspension of other rights going beyond limitation is only possible during properly declared states of war, mobilization, or state of emergency. And even then, it's only permissible for specific rights listed in Article 15. The measures must be strictly required by the situation, non-discriminatory, consistent with international law obligations, and defined by law.
Okay, that provides a clear picture of the rights framework. That brings us neatly to the operational side of the state, the institutions themselves. Let's start with the legislative branch, the parliament, the TBMM.
Right. The sources state the legislative term is 5 years, running between general elections. They also discuss midterm elections, or arasesim.
And those happen.
They can occur if seats become vacant. The sources say it's mandatory if vacancies reach 5% of the total seats, which is 30 deputies currently, or more, or if a whole province or electoral district loses all its representatives. It can happen discretionarily if vacancies are less than 5%, but only after 30 months of the term have passed, and generally not within the last year before a general election. Except if it's to fill seats in a constituency that has no representatives at all, then a midterm election can be held even in the last year.
So, quite specific thresholds and timing rules. Can general elections be postponed?
Only for one reason, according to the sources: war. If Turkey is at war and holding elections is impossible, the Assembly can vote to postpone them for 1 year. And if the war continues, this postponement can be repeated.
War is the only justification, and the election system itself.
The sources mention it's a single-round general election system. Parties need to clear a 10% national threshold to win seats in the Assembly, and seats are allocated within constituencies using the D'Hondt method, a proportional representation formula.
Okay, 10% threshold, D'Hondt system. How does the Assembly actually operate day to day?
Well, the legislative year runs from October 1st to September 30th. The Assembly actually convenes automatically on October 1st each year. No need for a special call.
It just starts work.
Pretty much. They can take a recess, but no more than 3 months in a legislative year. They can also take shorter breaks, up to 15 days. During these times, the president or the speaker can call them back for an extraordinary meeting, or if 1/5 of the deputies request it in writing, the speaker has to call them back.
So, ways to get them back to work if needed. And their internal workings are governed by
Their own rules of procedure, the ituzik. The sources mention this is sometimes called the silent constitution because it's so important for how Parliament functions. It's a detailed rule book.
the rule book for the rule makers themselves.
Exactly. Political parties form party groups if they have at least 20 members. These groups play a key role. The Assembly is headed by a speaker and a presidency council, elected from among the deputies, proportionally representing the party groups.
And voting. Are there special rules?
Yes. The speaker, or whoever is chairing the session, cannot vote. To even hold a meeting, they need a quorum of at least 1/3 of the total number of deputies, currently 200. To make a decision, they need a simple majority of those present and voting, but that number can never be less than 1/4 of the full membership plus 1, currently 151.
Those specific numbers, 200 to meet, 151 minimum to decide. That's quite telling. It means you need significant participation to get anything done.
It sets a minimum bar for legitimacy in action, yes. The sources mention 3 main voting methods: show of hands, open vote, which can be electronic or by roll call, and secret vote, often used for elections or sensitive matters, sometimes using colored balls. And bills are first debated in committees, which are specialized bodies elected proportionally from the party groups.
Okay, how does a bill actually become a law? What's the process?
A proposal, either from the government, though now primarily from deputies, or individual deputies, goes first to the relevant committee. The committee reviews it, potentially amends it, and sends a report to the full assembly, the General Assembly.
Then the main debate happens.
Yes. The General Assembly debates it, first the bill as a whole, then article by article. The sources note there's usually a minimum 48-hour waiting period between the committee report being distributed and the assembly debate starting, unless the matter is deemed urgent.
And the vote to pass it.
The vote to pass the law requires that simple majority of those present, again, provided the decision quorum of at least 151 is met.
And once the Assembly passes it, it goes to the President.
Correct. The president has 15 days. They can either approve it and promulgate it, publish it in the official gazette, making it law, or they can send it back to the Assembly with their reasons for objecting. That's the veto power.
Can the Assembly override a presidential veto?
Yes, they can. If the Assembly passes the exact same law again, unchanged, but this time with an absolute majority of the total number of deputies, currently 301, then the president must promulgate it. They don't get a second veto.
A higher bar to override. When do laws normally take effect?
The default rule, according to the sources, is 45 days after publication in the official gazette, unless the law itself specifies a different date, either earlier or later. The sources also mention that certain types of laws, special nature laws, require higher voting majorities to pass in the first place, like constitutional amendments needing a 35 or 23 majority, or amnesty laws needing 35.
Okay. Now, beyond making laws, the Assembly also makes parliamentary decisions. What are those?
These are defined basically as all other actions the Assembly takes besides enacting laws. Things like approving the budget, deciding to declare war, approving certain international treaties, electing officials like the Speaker or members of the Arctic Board, or as we'll see, lifting immunity.
How are they different from laws and procedure?
They are published directly in the official gazette as a TBMM Karare. TBMM decision, and crucially, they are not submitted to the president for approval or promulgation. The Assembly decides, and it's done.
And the general rule on judicial review, can you challenge these decisions in court?
The general rule, stated in the sources, is that parliamentary decisions are not subject to judicial review by the Constitutional Court or any other court.
Not subject to review. That seems like a significant power. Are there any exceptions?
Yes, and they are very important exceptions. The sources list 3 specific types of parliamentary decisions that can be reviewed by the Constitutional Court. First, the Assembly's own rules of procedure, the yashtazuk. Second, decisions lifting parliamentary immunity, yasama dokunulmazlu. And third, decisions regarding the loss of parliamentary membership for certain reasons.
Okay. So decisions about their internal rules and decisions directly affecting the status and rights of individual deputies can be checked by the court.
Exactly. The sources also note an interesting practice. The Constitutional Court has sometimes reviewed other types of Assembly decisions if it considers them to be, in effect, amendments to the rules of procedure, even if not formally labeled as such. So a slight expansion based on substance over form.
That makes sense. Subjecting those core procedural and membership decisions to external review provides a crucial check. Now, what about the deputies themselves, their legal status?
Well, the first principle is that deputies represent the entire nation, not just their constituency or party. They have 2 types of immunity, according to the sources, designed to protect their ability to function. First is yasama sorumsuzlugo. Let's call it absolute immunity or non-liability.
Absolute. Meaning?
It means complete protection for their votes, their words, and their thoughts expressed during Assembly work. This covers debates in the General Assembly, committee meetings, party group meetings, etc. They cannot be held liable, civilly or criminally, for what they say or how they vote in these contexts. And this immunity is permanent. It continues even after their term as a deputy ends.
So complete freedom of speech related to their parliamentary duties forever.
Yes, that's the idea. To allow for free and open debate without fear of prosecution. The second type is yasama dokunulmazlu, relative immunity or inviolability.
Relative. How is it different?
This is temporary protection. It shields deputies from being detained, questioned, arrested, or put on trial for alleged crimes committed outside their Assembly duties, whether those crimes allegedly occurred before or after they were elected. This protection lasts only as long as they hold their seat as a deputy.
So they generally can't be prosecuted for ordinary crimes while they're serving, unless
the Assembly votes to lift this relative immunity for a specific case. The idea is to prevent politically motivated or harassing prosecutions from interfering with their legislative work.
But are there cases where this relative immunity doesn't apply automatically?
Yes, the sources list 2 important exceptions. First, if they are caught in the act of committing a crime that requires heavy punishment, grave flagrante delicto. Second, if an investigation into alleged activities against the state's integrity or fundamental rights under Article 14 of the Constitution had already started before they were elected. In these specific situations, the authorities can proceed without needing the Assembly to lift immunity first.
Okay, specific carve-outs. And if the Assembly does vote to lift immunity in a regular case, is that decision final?
No. The concerned deputy or any other deputy can appeal the Assembly's decision to allow immunity directly to the Constitutional Court. They have only 7 days to file the appeal, and the court must make a final ruling within 15 days. It's a very rapid, specific judicial review process.
A quick check, and this relative immunity only covers criminal prosecution.
Yes, the sources specify it only protects against criminal proceedings, detention, arrest, trial. It does not prevent civil lawsuits against a deputy. And remember, it's temporary. It ends when their term ends. The sources also mention that vice presidents and ministers benefit from the same relative immunity while in office.
Okay. What about a deputy losing their seat entirely? What are the constitutional grounds for that?
The sources list several ways this can happen. Resignation. A deputy can resign, but it only takes effect after the General Assembly formally accepts it by vote.
So they have to vote to let someone resign.
Yes. Second, persistence in an incompatible duty. If a deputy insists on holding a job or position deemed incompatible with being a parliamentarian, the Assembly can vote by secret ballot to remove them. Third, absence. If a deputy misses 5 session days in 1 month without a valid excuse or leave, the Assembly can vote by absolute majority of the full membership to end their membership.
So attendance matters.
It does. Fourth, final conviction or restriction. If a deputy receives a final court conviction for a crime that prevents them from being elected, or if they are legally restricted, for example, declared mentally incompetent, their membership ends automatically. The Assembly is simply notified of the final court decision and the membership ceases. No Assembly vote is needed for this one.
Automatic loss upon final conviction. Can these decisions on loss of membership be appealed?
Yes, for the first 3 grounds, resignation, acceptance, removal for incompatible duty, or removal for absence, the concerned deputy or another deputy can appeal the Assembly's decision to the Constitutional Court. Again, it's that same quick process. Appeal within 7 days, court decision within 15 days.
But not for the automatic loss due to conviction.
Correct. That's based on a final court judgment, so the appeal route is through the regular judicial system, not this specific parliamentary appeal to the Constitutional Court. The sources also explicitly state that political party groups within the Assembly are forbidden from even discussing or making decisions regarding lifting immunity or loss of membership. These are considered matters for the Assembly as a whole or the courts.
That covers the legislative branch pretty thoroughly. Now let's turn to the executive branch. You're with me.
Right. The sources state clearly that under the current system, the executive organ consists of the president, vice presidents, and ministers, a more streamlined structure than the previous parliamentary system.
And the presidency itself. Its role and powers changed dramatically with the 2017 constitutional amendments, shifting to a presidential system.
Yeah.
How's the president elected now?
Since those changes, the president is elected by direct popular vote. To win, a candidate needs an absolute majority, more than 50% of the valid votes. If no one gets that in the first round, there's a second round runoff between the top 2 candidates.
Term length. Limits.
The term is 5 years, and a person can be elected for a maximum of 2 terms.
Only 2 terms.
Generally, yes. But there's a specific interesting exception mentioned in the sources. If the Assembly decides to call for early elections during the president's 2nd term, then the incumbent president can run again for a 3rd term.
A specific loophole or condition for a 3rd term?
Yeah.
What are the basic qualifications to even run for president?
You need to be a Turkish citizen, at least 40 years old, have completed higher education, and meet the general eligibility requirements for being elected as a deputy.
How do candidates get nominated?
Political party groups in the Assembly that received a certain percentage of votes in the last election can nominate a candidate, or individuals can be nominated if they collect signatures from at least 100,000 voters.
Okay. Party nomination or popular nomination. What happens if the presidency becomes vacant, say, due to death or resignation?
An election for a new president must be held within 45 days. In the meantime, a vice president acts as president, exercising presidential powers.
And the term limit calculation for someone elected in that situation?
The sources note a specific rule here. If a president is elected to fill a vacancy when there's more than 1 year left before the next scheduled general election date, the time they serve until that general election does not count towards their 2-term limit. If there's less than a year left, it does count as 1 full term.
That's quite a detailed rule. Now, the powers of the president under this system, they seem expensive based on the sources.
They are significantly strengthened compared to the previous parliamentary system, yes. The president is both head of state and head of government. They appoint and dismiss vice presidents and ministers directly.
Major appointments. What else?
They issue presidential decrees, which have the force of law in certain areas, and regulations. They can call the TBMM to extraordinary meetings. They can decide to renew the parliamentary and presidential elections. They appoint most high-level state officials.
Military and security roles.
Yes, the president serves as commander-in-chief of the armed forces, represented by the president, appoints the chief of general staff. They convene and chair the National Security Council, MGK. They can declare a state of emergency or mobilization or war, although assembly approval is needed for these declarations to continue or have certain effects.
Foreign policy. Judicial appointments.
They sign international treaties. They represent the Republic of Turkey abroad and receive foreign representatives. They appoint a significant number of judges to high courts, including 12 out of 15 members of the Constitutional Court and members of the HSK Judges and Prosecutors Council. They also appoint heads or members of other key bodies like the Court of Accounts, Sayıştay, the Higher Education Council, UK, and the Radio and Television Supreme Council, RT.
Pardons. Government structure.
They have the power to commute or pardon sentences of certain convicts, and they can establish, abolish, or reorganize ministries and state organizations through presidential decree. It's a very broad range of executive authority.
With such broad powers, how is the president held accountable, especially for potential crimes committed while in office?
The sources describe a specific impeachment-like process for criminal responsibility. It applies to a crime allegedly committed by the president. While in office, the sources interpret the 2017 changes as removing the previous limitation to just treason.
So, any alleged crime, how does it start?
It starts with a proposal to open an investigation submitted by at least a simple majority of the full membership of the Assembly, 301 deputies. The Assembly debates this proposal and votes on whether to actually open the investigation. This requires a higher threshold, a 3/5 majority, 360 deputies, voting in secret.
A significant hurdle just to start investigating.
Yes. If the investigation is approved, a special 15-person commission is formed. Members are chosen by lot from candidates nominated by party groups in proportion to their seats. This commission conducts the investigation and must submit its report within 2 months, with a possible 1-month extension.
And after the report?
The report is debated by the General Assembly. To refer the president to the Ustavan, the Supreme Criminal Court, which is the constitutional court acting in this capacity, requires an even higher majority. A 2/3 vote, 400 deputies, in a secret ballot.
2/3 majority to send to trial. That's a very high bar.
Extremely high. If referred, the Ustavan Constitutional Court conducts the trial, which should be concluded within 3 months, extendable once for another 3 months.
What are the consequences if the Ustavan convicts the president?
If the conviction is for a crime that prevents them from being elected, their presidential duty ends immediately. The sources also add a couple of interesting points. A president who is under investigation cannot call for new elections, and this entire criminal responsibility process can also be initiated after the president leaves office concerning alleged crimes committed during their term.
So accountability extends beyond their time in office. What about vice presidents and ministers?
They face a similar Ustavan investigation and trial process for crimes related to their duties. For alleged crimes not related to their duties, they benefit from the same relative parliamentary immunity, yasamadakul mazlu, as deputies while they are in office.
Okay. The sources also mention the State Supervisory Council, the DDK. What's its role?
It's an auditing and inspection body attached directly to the presidency. It conducts inspections, investigations, audits, and administrative inquiries into a wide range of bodies: public institutions, state-owned enterprises, professional organizations like bar associations or chambers of commerce, worker and employer organizations, public benefit associations, and foundations.
Does it act on its own initiative?
No, that's a key point from the sources.
Yeah.
The DDK acts only upon the request or instruction of the president. It doesn't launch investigations independently. Its reports are submitted to the president and are generally confidential.
So a tool for the president to investigate various parts of the administration and semi-public sector. What forms do the executive's own regulatory actions take now? You mentioned presidential decrees.
Right. Since the 2018 system changed, the main regulatory instruments of the executive are presidential decrees, Cumhurbaşkanlığı, Kararnameleri, and regulations, Yönetmelikler. The sources note that previous forms like tüzüks, cabinet-issued regulations, and decree laws, Kanun Hükmünde Karanes, or KHKs, which were often used during states of emergency, were abolished.
What can presidential decrees cover? Are there limits?
Yes, there are important limits. Presidential decrees cannot regulate matters that the Constitution explicitly states must be regulated exclusively by law. They also cannot regulate fundamental rights, personal rights and duties, or political rights and duties listed in the Constitution. Those areas are reserved for laws passed by Parliament. They primarily deal with executive matters, organization of the administration, etc.
And regulations.
Regulations are lower-level rules issued by the president, ministries, and other public legal entities to implement laws and presidential decrees. Some need to be published in the official gazette to take effect. Both presidential decrees and regulations are subject to judicial review by administrative courts, specifically the Council of State, Danıştay, for nationwide regulations or presidential decrees, and lower administrative courts for local ones.
Okay. And the National Security Council, the MGK, still exists.
Yes. The sources list its members, chaired by the president, includes vice presidents, the ministers of justice, national defense, interior, foreign affairs, the chief of general staff, and the commanders of the land, naval, and air forces.
What does it do?
The president sets the agenda, drawing on proposals from vice presidents and the chief of staff. The MGK discusses national security policy and makes recommendations on necessary measures. The sources state its decisions are evaluated by the president, implying they are advisory. It meets at least once every 2 months.
And finally, under the executive, the state of emergency, SOE.
The president has the authority to declare a state of emergency in one or more regions or the whole country for reasons listed in Article 119, serious indications of widespread violence aimed at destroying the democratic order or fundamental rights, or serious deterioration of public order due to violence, or natural disasters, dangerous epidemics, or severe economic crises.
How long can it last? Does the Assembly have a say?
The initial declaration by the president cannot exceed 6 months. It must be submitted to the TBMM for approval on the same day it's declared. The Assembly can approve it, shorten the duration, extend it, or lift it entirely. If the Assembly requests an extension, it can be for a maximum of 4 months at a time. However, during wartime, this 4-month limit on extensions doesn't apply.
And what happens during an SOE regarding rights?
The Constitution allows for certain obligation, like financial, material, or labor contributions, to be imposed on citizens. And as we discussed earlier, fundamental rights and freedoms can be partially or entirely suspended, but only in accordance with the principles laid out in Article 15. Measures must be necessary, proportionate, non-discriminatory, consistent with international law, and defined by law. And those hardcore rights remain untouchable even during an SOE.
Okay, that brings us logically to the third pillar of the state, the judiciary branch, Yargı.
Right. And the foundational principle here, stated in Article 9 of the Constitution, is that judicial power is exercised by independent and impartial courts on behalf of the Turkish nation. The sources highlight that impartial was explicitly added alongside independent in the 2017 amendments, reinforcing this core value.
Independence and impartiality, key principles. What about the HSK, the body overseeing judges and prosecutors?
Its name changed slightly. It used to be the High Council, now just the Judges and Prosecutors Council, Hakimler ve Savcılar Kurulu. Its structure was also significantly altered in 2017. It now has 13 members.
Who are they? How are they chosen?
The Minister of Justice serves as the president of the council. The relevant Deputy Minister of Justice is also an ex officio member. Then 7 members are elected by the Parliament, TBMM, from candidates with specific legal backgrounds. 3 from the Court of Cassation Judiciary, 1 from the Council of State Judiciary, 3 academics lawyers. And the remaining 4 members are appointed directly by the president, again from specific categories of judges, academics, and lawyers.
A mix of judicial, parliamentary, and presidential appointments. What does the HSK do?
It handles the administration of the judiciary regarding judges and prosecutors, excluding those in the Constitutional Court. This includes appointments, transfers, promotions, disciplinary actions, and dismissals.
Are its decisions final? Can they be challenged?
This is a crucial point from the sources. Only HSK decisions regarding dismissal from the profession are explicitly stated as being immune from judicial review. All other decisions made by the HSK, appointments, transfers, disciplinary actions short of dismissal, are subject to judicial review by the Council of State, Danıştay.
So a check on most of its powers, except the ultimate sanction of dismissal. Now, the sources list 4 high courts. What are they?
Yes, the top tier of the judicial system. They are the Constitutional Court, Anayasa Mahkemesi, the Court of Cassation, Yargıtay, the Council of State, Danıştay, and the Court of Jurisdictional Disputes, Uyuşmazlık Mahkemesi.
Why are they called high?
Because their decisions within their respective areas are final. The Yargıtay is the final court of appeal for ordinary civil and criminal cases. The Danıştay is the final court of appeal for administrative and tax cases, and it also has some first instance jurisdiction and advisory roles, like giving opinions on draft laws or concession agreements. The Uyuşmazlık Mahkemesi resolves conflicts about which branch of the judiciary, ordinary, administrative, etc., has jurisdiction over a specific case.
And the Constitutional Court has its own unique functions. We also heard military courts were mostly abolished.
Correct, according to the sources. Since the 2017 amendments, military courts, except for military disciplinary courts, cannot function in peacetime. They can only be established during wartime to try military personnel for offenses related to military service.
Now, let's focus now on the Constitutional Court, the Anayasa Mahkemesi, or AM, established back in 1961. How is it composed?
It has 15 members in total. The selection is split. 12 members are appointed by the President of the Republic. These appointments are made from candidates nominated from various high courts, Yargıtay, Danıştay, military high courts, though that pool is changing, the Court of Accounts, university professors in law, economics, political science, senior administrators, and lawyers. 3 members are elected by the Parliament, TBMM, from candidates nominated by the Court of Accounts and the heads of bar associations.
So a mix of presidential and parliamentary selection from specific professional backgrounds. How long do they serve?
Members serve a 12-year term and cannot be re-elected. They retire automatically at age 65. The members elect a president and 2 vice presidents from among themselves for a 4-year term, renewable. They cannot hold any other official or private jobs while serving. Membership ends upon conviction for a crime requiring dismissal, or if they're unable to serve due to health reasons, decided by an absolute majority of the court.
Okay. Now, its duties. Beyond reviewing laws, which we'll come back to, the AM has other significant roles, especially one added more recently.
Yes, a major one highlighted in the sources, introduced in the 2010 constitutional amendments, is the individual application mechanism, Bireysel Başvuru.
What does that allow?
It allows any individual, not just citizens, but potentially anyone under Turkish jurisdiction, to apply directly to the Constitutional Court if they believe one of their fundamental rights or freedoms, specifically those guaranteed by the Constitution and also covered by the European Convention on Human Rights, ECHR, has been violated by a public authority.
A direct route for citizens' rights complaints to the highest court. That sounds powerful.
It is potentially very powerful, but there's a crucial condition. The applicant must have already exhausted all ordinary legal remedies available to them through the regular court system first. You have to try the normal appeal routes before going to the Constitutional Court with an individual application.
So it's a final backstop. Is there a time limit?
Yes. The application must generally be filed within 30 days of exhausting those ordinary remedies, or within 30 days of learning about the alleged violation if no remedy was available.
How does the court handle these cases?
There's an admissibility review first, usually by smaller commissions, to see if the formal requirements are met, like exhaustion of remedies, timeliness, whether the right claimed is covered. If admissible, the case goes to one of the court's 2 chambers, Belemler, for a decision on the merits. Was there actually a violation?
And if they find a violation?
The court identifies the violation and sends the decision to the relevant authority to remedy it. This doesn't usually mean the Constitutional Court retries the case itself, but it often means the original court case has to be reopened or reconsidered to eliminate the violation and its consequences. It's a significant mechanism for enforcing ECHR standards domestically.
Definitely sounds like it. What are the Constitutional Court's other specific roles?
Well, it acts as the court for deciding on the closure of political parties based on actions contrary to the Constitution. It also handles the financial audits of political parties, usually with assistance from the Court of Accounts.
Okay, party regulation.
It also reviews those specific TBMM decisions we mentioned earlier, the ones lifting parliamentary immunity or causing loss of membership. Deputies can appeal those decisions directly to the AM, and it appoints the president of the Court of Jurisdictional Disputes from among its own members or those of the other high courts.
And its role as the jus divan.
Yes, the Constitutional Court sits as the jus divan Supreme Criminal Court to try the highest state officials for crimes related to their duties. The list, according to the sources, includes the president, vice presidents, ministers, the Speaker of Parliament, the Chief of General Staff, force commanders, heads, and members of the high courts, including the AM itself, the HSK, the Chief Public Prosecutor of the Yargıtay, and the President and members of the Court of Accounts.
A very specific list of top officials. Who acts as prosecutor?
The Chief Public Prosecutor of the Yargıtay, Court of Cassation, or their deputy, acts as the prosecutor in jus divan trials. The sources mention these trials have a time frame, usually 3 months, extendable ones.
Okay, now let's get back to what many see as its most traditional and defining role. Norm review, checking the constitutionality of laws and other norms.
Absolutely. This is a cornerstone function, safeguarding the supremacy of the Constitution and the rule of law state, introduced back in 1961 when the court was created. Ordinary courts in Turkey cannot declare laws unconstitutional. Only the Constitutional Court can do that.
How can a law or other norm be challenged? The sources describe two main methods.
Yes, abstract review and concrete review.
Let's take abstract review first, also called annulment suit. İptal davası.
Right. This is a direct challenge to the constitutionality of a norm, a law, a presidential decree having the force of law, or the parliament's rules of procedure, uçtüzük, brought shortly after it's enacted, independent of any specific ongoing court case.
Who can bring such a direct challenge?
Only specific actors listed in the Constitution. The President of the Republic, the two political party groups with the largest number of seats in the parliament, or a group of at least 1/5 of the total number of deputies, currently 120.
So, high-level political actors, is there a time limit?
Yes, a strict one. The suit must be filed within 60 days of the publication of the challenged norm in the official gazette. For challenges based only on formal defects, like procedural errors and how it was passed, the time limit is even shorter, just 10 days.
And the court's decision?
If the court finds the norm unconstitutional, it annuls it. The decision is final and binding, published in the official gazette, and usually takes effect on the date of publication, though the court can postpone the effect for up to 1 year to allow Parliament time to fix the issue.
Okay, so certain political actors can take a new law directly to the AM to be potentially scrapped. What's the second method? Concrete review.
Concrete review, also called the objection or preliminary reference method, itiraz yolu. This arises during an ongoing case before any regular court in the country.
How does it work?
If a court hearing a case finds that the law or presidential decree it needs to apply to decide that case might be unconstitutional, or if one of the parties involved in the case makes a serious claim that the applicable norm is unconstitutional, the court must pause the proceedings.
It just stops the trial.
Yes, it suspends the case and refers the question of constitutionality up to the Constitutional Court. It essentially asks the AM, is this rule constitutional? We need to know before we can apply it.
So a regular judge, or even a party in a lawsuit, can trigger a constitutional review of the law relevant to their case.
Exactly. The Constitutional Court then has 5 months to decide on this referral. If the AM doesn't issue a decision within 5 months, the lower court must proceed with the case using the existing law. However, if the AM's decision does come later, even after the lower court has ruled, the courts must comply with the AM's finding regarding constitutionality, potentially requiring the case to be reconsidered.
Interesting dynamic. Can you challenge formal defects this way?
No, the sources state that concrete review cannot be based on alleged formal defects in the lawmaking process. Also, if the Constitutional Court rejects a claim of unconstitutionality raised via this concrete review method on its merits, the same claim about the same provision cannot be raised again before any court for 10 years.
A 10-year cooling-off period for that specific issue. This seems like a way to integrate constitutionality checks throughout the entire judicial system.
It is. It allows constitutional questions arising from real-life cases to reach the highest court.
And how does the Constitutional Court manage all these different types of cases? Individual applications, party closures, norm reviews, Yustavon trials internally.
The sources mention the court's internal structure. It has a General Assembly, Genel Kurul, and 2 chambers, bulunmalar. The chambers primarily handle the bulk of the individual application cases. The General Assembly, which requires a quorum of at least 10 members out of 15 total, handles the major cases: political party closure suits, the abstract and concrete norm review cases, annulment suits and objections, and the Yustavon trials.
Wow, okay. That paints a really comprehensive picture. From the basic building blocks to the detailed workings of Parliament, the presidency, the courts, and the rights framework. It's a lot to take in.
It's definitely a complex system, but hopefully breaking it down like this, drawing directly on what the source material tells us, helps reveal the underlying structure and logic. It's fascinating how it all interconnects.
Absolutely. And that really wraps up our deep dive into the Turkish constitutional system for today. We've journeyed quite a distance from the fundamental definitions of state and constitution.
Right through the country's really dynamic constitutional history.
Explored those core principles that define the republic today: secularism, rule of law, social state.
Delved into the framework of your fundamental rights and freedoms, how they're guaranteed and how they can be limited.
And detailed the structure and specific functions of the legislative branch, PBMM, the executive branch, the presidency, and the judicial branch, including that crucial constitutional court.
Our goal, really, was to pull out the most important knowledge and insights from the material we had, to give you a clear, hopefully engaging and well-informed understanding of this critical topic without getting totally lost in the weeds.
We hope we managed that. Now, as we finish, here's a final thought for you to maybe ponder, building on everything we've discussed from the sources. Reflecting on the significant transformations Turkey's constitutional system has seen since, say, 1876, the shifts between different systems of government, the changes in how rigid or flexible the Constitution is, the evolution and sometimes restriction of rights, the creation of powerful checks like the Constitutional Court. What does this ongoing process, this constant adjustment and change, suggest about a nation's continuous effort to define itself, to balance power, and to secure the rights of its people? How does seeing this historical and structural dynamic laid out maybe inform your understanding of the country today?
Definitely something powerful to think about. The Constitution isn't static.
Indeed. Well, thanks for joining us on this deep dive. We hope it was valuable for you.